Blandino, I'm gonna put some things on the record. You're referring to December 30th, order, and I don't know what order you're referring to.
No, December 20 order. This is the Linda Marquis order.
Well, the order.
Oh, I'm sorry, you're right, it says for a status check on December 20.
That's right.
But it
So
said
it's
December
actually
6th.
a December 6th order.
Oh, you're right, I been goofed up, I
Alright.
apologize.
No, that's okay, it happens, but.
But I did set those appointments in this email.
Okay, Mr. Blandino, let me finish
Okay.
things on the record, okay?
Yeah.
So this is a December 6th email where Judge Marquis put a number of things on the record and made a number of findings. Of importance to what we're here for today, it specifically says on page 2 of that order, paragraph number 1, that within 7 days of this written order, Mr. Blandino shall make evaluation appointments with Dr. Capel,
Which is undisputed, I did,
or Dr. Slagle, and he can contact them and they provided the contact information.
which I did.
I also find that that office attempted to schedule appointments for you for both December 11th and December 16th. But you advised as you said here in open court, you were, quote, not available for the December 11th date, and you provided no reason why you couldn't be seen on the 16th. Instead, you decided...
No, I was never told about the 16th, Judge. All I was told is that I had an appointment. My recollection now is that I had an appointment for the 26th, and they told me over the phone. I wish I'd have recorded that darn thing, but I didn't.
Well, that would be another crime, so don't do that.
Yeah, but if I would have law enforcement there, because there's a potential crime in progress, especially if you put me in jail, that'll be a compounded crime. They said the 26th, they said, we'll call you later to schedule the one for Dr. Slagle. So at that point, when I hung up the phone, I thought everything was fine and dandy. The email that I showed you shows you that says, and it's not a cut and paste, it's just what's called a continuation, where you got REs back and forth. And it says that we can't do anything for you by the 20th date. You're going to have to work this out with the courts. Do you see that? Now, I was denied to present this information to Judge Bell last time, just to make a record, even though she had no business being in on the case. But because I'm being denied these rights, especially to make a record, it's very, very tough to do this.
Well, I do find that there was an attempt to have you go in on December 11th, and I still have no reason as to why, other than your representation that you were unavailable, but you don't have a reason.
No, see, this is not a static conversation where it's text back and forth. I said, is the 26th good? And they said yes.
That was good because they had an availability, but to comply with Judge Marquis' order, it had to be before the 20th.
No, that's not true. Read the order. This matter is on for a calendar for a status check on December 20.
You're right.
So if I would have come in here...
Actually, it would have been before December 13th.
It doesn't say the evaluation had to be done by that date, Judge, and you have to know that it could very well, I could have said, hey, look, I got an appointment with Judge Capel for the 26th, and then a Judge Slagle on so on and so forth, and whoever was sitting on the bench could have said, okay, yeah, that's fine.
Let me ask Mr. Dickerson a question about that, because the order actually does say, Mr. Dickerson, that he has to make evaluation appointments within 7 days of the order.
Exactly, and I was in total compliance with that.
Mr. Blandino.
Yes.
So the ruling from the bench was that he had to get the evaluation done within 7 days.
No, that's not true. It doesn't say that.
Mr. Blandino.
Those are the notes that I have, and that's what I'm showing.
Yeah, don't go by the judge's signature on a signed and filed order. Go by his note. Yeah,
So,
this is America.
Ultimately, it's quite clear exactly what Mr. Blandino is doing in trying to push this out past the status check. He has no good reason that he's proffered to this court as to why he couldn't attend any of the dates that were offered by the psychiatrist, especially considering that those were dates that were offered for both of the psychiatrists to be present during the evaluation.
No, they offered the 26th date, Judge. I took that 26th date and they said...
I see that.
And the 26th date was only for Dr. Gaffney. Dr. Slagle never confirmed for a 26th date, so the defendant never actually scheduled his psychiatric
I tried to.
Since he's required by statute to have two, so he didn't schedule those within the time required by this order or by the ruling from the bench. Either one, the defendants failed and violated this order.
No, that's not true. You're going to take a rule. This is absolutely wrong. I did that quicker than the 7 days. I called up that very day, went down to their office that very day. She said she couldn't do anything until she heard from her doctors. When I called and made that appointment, as far as I knew, the 26th date was fine and dandy, everything was good. Got off the phone, and they said, before I got off the phone, they said, we'll have Dr. Schlegel, make his appointment with you. And so, it could have been before or after. If this order would have said, Judge, if this order would have said, you, Mr. Blandino, shall have those appointments set before December 20, absolutely, my client, me, would have done so. It says for a status check. I've seen over and over again where they do status checks, and you go and you remand me like this district attorney wants. You watch how I'm slow played through the system. Maybe a month and a half in custody before somebody comes to evaluate me. And will he be complaining about abusing the process? Absolutely not. This mental health system spends less than any place in the country. It's under a federal consent decree because of the numerous violations that they've done. And I'll tell you what, I was going to do an emergency motion to the Nevada Supreme Court prior to this hearing, anticipating that there might be some more lies here, and I said, no, we'll see what happens on this, because I still got the motion to disqualify. You know, you can't sit on the bench, Judge. There's still an outstanding motion to disqualify. You have to know that. 1.230 and 1.235 is very specific. Until there's been a determination on the motion to disqualify, the court can proceed no further, and that includes you.
Okay, Mr. Blandino, so I'm reviewing the transcript from the proceeding with Judge Marquis.
The transcript that I paid for.
The transcript says specifically, make an appointment, you'll get it in my written order, that will be issued by 5 p.m. today. That will be filed into the case and you will have access to it. I'm not going to grant their motion to remand, however, I'm going to see you back, not next Friday, but the Friday after. And we better have these appointments made, and I want verification from the doctors that they were done. In addition to the requirement of your release, you are the following. You are not to have any contact with Talia Williams privately or in a professional contact. Your question will be part of the written order. Yes, thank you very much, I appreciate that. And then you were also ordered not to have any contact with Judge Levitt or Judge Delaney. And then there was some back and forth because you continued to interrupt the judge. Okay, so specifically again, the judge said, we better have those appointments made, and I want verification from the doctors that they were done. So we're sitting here now on January 23rd.
Now, appointments made, that's key, Judge, if you point to that, the appointments were made. I made an appointment that they said was good to the 26th, and I was supposed to get a call back.
Except they were supposed to be done by December 20th.
There's nothing on that order. I was required to do within 7 days, which I did.
And there were supposed to be appointments with 2 doctors.
Correct.
And he knew the whole time that he only had 1 appointment.
Correct. So you can't do 50% of the work, Mr. Blandino, and then be surprised that the court is going to have issue with the fact that not only did you not follow what Judge Marquis said and get those 2 appointments done, not just 1.
They refused to do them. They said it was beyond the 20th date, and I had no idea that there was.
Mr. Blandino, stop interrupting me. Based on the information before me, it appears that they attempted to work with you not just on 1 occasion, but 2 occasions, that being December 11th and December 16th, both of which would have been
I thought this was the 16th.
December 11th and December 16th.
16.
Which is what, which would have been before
I
the
never got a
December-
16th date.
Ms. Blandino, let me finish talking.
Yeah.
Which would have been within the, not only the 7-day range that was discussed before Judge Marquis, but well before the 20th day that was initially set for a status hearing, where you would have followed the order, we better have those appointments made, and I want verification from the doctors that they're done, that the appointments are done. So, what you did do is you did 50% of the way, and I do give you credit for that. You did attempt to make an appointment, and you got an appointment, of course, all that on your schedule. I still have no explanation or excuse as to why you did not go on December 11th of 2019, which would have been within the court.
Because they gave me an appointment for the 26th. This was a banter back and forth where you're trying to reconcile schedules. The court does this with the attorneys all the time, where you're setting a date. Oh, can we make it this? No, I've got this, I got that. And they said the 26th. Why? You can't sit there and say that I did half the work. I did the entire amount of work. I set the appointment the 26th. I thought everything's fine. It doesn't say in this order that the appointment has to be before the 20th. And so they said they were gonna call me back, or Schlegel was gonna set up an appointment. Now, it may have been before the 26th or after the 26th, it's up to his schedule. But you're making it sound like I just purposely did 50% of the work and I complied specifically with this order as written. Now, if Judge Marquis, wanted to do this and say, your appointments have to be set for December 20th, I would have done that. And I would have gone to the commission, or the Nevada Supreme
Blandino,
Court.
you were here in open court when Judge Marquis told you that appointments had to be made and verification had to be done. You received that order that said within 7 days of that appointment, you had to have those appointments made. You didn't do that.
Yes, I did.
relying on the December 26th date, but it was made, that's well after the 7 days.
You are twisting the facts here, Judge. You are clearly biased in favor of the district attorney here. I said biased. I am going to file, I'm gonna have to file another motion to disqualify you.
Well, you're gonna need to follow the court procedure for
But
doing that.
why do you want to only do half the work? There's a motion to disqualify.
Please
You
lower your
can't do
voice,
anything in this
Mr.
case.
Blandino, lower your voice.
You can't do anything in this case with an
I
outstanding
am
motion
going
to
to grant the
disqualify.
state's request to remand Mr. Blandino to custody.
Haha, yeah.
Be taken into custody at this time.
All right, can I, no.
I am going to order that Mr. Blandino also be evaluated while he's in custody pursuant to the pending.
Are you gonna give a timeline for that, Judge?
It'll be with the, in the normal course of the.
Oh, the normal course, which could be 3 months from now until I get evaluated. This is outrageous, Judge. I object to what you're doing. You're taking an evidentiary hearing based on hearsay.
I'm advised by the
This is
court
outrageous.
staff that it'd be 3 weeks, within 3 weeks time it'll be evaluated.
Thank you very much. I
Thank you,
appreciate
Your
that. All right, is there anything further the state needs to put on the record? Mr. Mark, is there anything else you need to put on the record?
No, Your Honor, I think that we just need another date. I apologize. 3 weeks, is that what the court said? 3 weeks would be best to be able to get those evaluations done.
All right.
January 24th at 10 a.m.
All right, for the record, Mr. Blandino has been removed from the courtroom. His next court date will be January 24th, 2020. I do find that Mr. Blandino violated the court's oral order back on December 6th of 2019, where he was ordered to get those appointments done and made and verified that they were taken care of within 7 days of that court order. The evidence before the court shows that he attempted to comply, but again, he admitted in open court that he did not go to the December 11th date. He denies that he was ever contacted about the 16th. He provided no explanation or justification for missing the December 11th date, and instead relied on a date of December 26th. While that was somewhat partial compliance, it certainly wasn't full compliance, and it is not the first time, as I understand, Mr. Blandino has refused to go to the competency evaluations as ordered. He was released from custody, and I do not find that he was under any pretrial punitive action or any other issue with pretrial release. He was subject to the standard release of a pretrial detainee with conditions which are proper. Anything else we need to put on the record?
Nothing to say, Your Honor. Thank you.
All right, thank you very much. January 24th. And for the record, I am adding the emails and card that Mr. Blandino provided to the court file.
And I would just ask that if the email I provided the court is added as the court's exhibit, that the email and phone number be redacted.
Do you want to make exhibits or website files? I don't think website files, but I mean, you want me to do it after that.
Thank you so much.
Yes. Thank you.
That's me.